So let's look at the rest of the arguments. One of the arguments Wayfarer makes is she was not employed by anybody on that side of the V at the time the alleged retaliation occurred. One of the elements of retaliation is an adverse employment action. You can't take an adverse employment action against somebody who isn't your employee, right? So in response to a motion for judgment on the pleadings, the argument Lively would make is, look, the loan out agreement and the rider clearly say that I am still employed while the promotion of the film is going on. And the smear campaign started when we were still promoting. So I was your employee when this happened. That's a straight legal argument because, again, you're just looking at the complaint and the answer and what was attached. But if she wanted to turn that into a fact issue, if she were arguing that in summary judgment, she could bring in all kinds of things from all kinds of places, right? She could say, okay, the same thing, the language of the loan out agreement makes it clear that promotion was part of the job. She can also make arguments about this case is different than others because I'm in a unique business. Movie promotion is not normal employment. Reputation is more important in my business than it is in other businesses. I testified at my deposition about how all this was supposed to, she can bring in other evidence. She could potentially, this is a place where she could try to bring in experts on this issue and try to create issues to say, you can't get rid of this claim yet, Your Honor. We need to let a jury see this and we need to let a jury decide what the actual right thing is. She could also bring in evidence that shows that Wayfarer considered her part of the production when the campaign was happening. Let's just say that there's an email out there from Jamie Heath or Justin Baldoni or Steve Sarowitz or somebody to Blake Lively on August the 13th saying, sorry you're really going through it. We're so glad you're still part of our team. Right? So for summary judgment, you can bring those things in. For a motion for judgment on the pleadings, you can't. On the issue of temporal proximity for causation, for retaliation, it happened 8 months apart or 12 months apart or 15 months apart, and the law says if it's not within 3 months, it's suspect, right? So the legal defense to that for Lively would be, the timing is what it is. She's alleged it in her complaint, so she can't really argue the timing. What I see to be the best argument for her for law only is, and I just looked briefly at the parentheticals that Wayfarer put in their document, that the cases they're relying upon that say a case can go away because of a lack of temporal proximity are not MJOP cases, they are summary judgment cases. And so you're asking the judge to rule on a motion and you're not giving him examples of people ruling on that same motion, which is a pretty regular tactic. But if she can bring in facts, then in the motion for summary judgment stage, she's going to say, well, causation's a fact issue, and let me tell you how I know. Because yes, 15 months passed between me engaging in protected activity and the retaliation happening or the adverse employment action happening. But I've got somebody who's going to testify that they heard Justin Baldoni tell someone at Tao at the end of May that he was still upset that I had accused him and that he was going to get me back somehow. Right? So motion for summary judgment, you can bring in facts. MJOP, you can't. When you get to the Friedman stuff, these to me are the ones that are the most straightforward legal questions. It's like either Friedman's statements are part of the litigation privilege or they're not. Right? Either their opinion or they're not. And we know that Judge Lyman has already ruled on dispositive motions on these issues. And so it would make sense for him to feel comfortable to do it again. The response on both of these is basically just nuh-uh, right? On the MJOP, she's going to say litigation privilege doesn't apply because you said this stuff to Megyn Kelly. That's going to be a legal question. That's going to be case law and precedent. With the opinion, it's just going to be an argument about whether his statements are opinion or not, if you even get there. Because if they're privileged, it doesn't matter whether it's opinion. On the issue of Friedman's comments being covered by the litigation privilege, I think she could try to devise something that's like, this is a defamation claim, And whether he thinks these things are false is kind of a fact issue. But if she argues that, then she is making him a fact witness, and he has got a real problem representing his clients in this case. And I just don't know if the judge wants to go there. When it comes to opinion, opinion, there's the straight up legal argument about what is and isn't opinion, and we've seen him do that before. The only way she could really make a fact issue out of that is by saying, this is not someone going out there and saying, oh, I think my client has a great case, I really hope we prevail, that there is a difference. There is a qualitative difference in a lawyer going out and saying, that plaintiff is lying and she's making the whole sexual harassment thing up, that is not necessarily an opinion. That is something that we have to figure out whether that's an opinion or not. We need facts, ergo it's a fact issue, ergo it has to go in front of a jury. And then when it comes to civil conspiracy, that's a tag along, because as I've said before, you can't have a conspiracy, you have to have a conspiracy to do something. And so it has to be a conspiracy to defame, a conspiracy to retaliate, a conspiracy to discriminate. So if you can pull away all of the other claims, then the conspiracy falls too. So Lively's people and Lively want to make everything into a fact issue. No, we got to kick this can down the road because we've discovered that there are conflicting facts here and we need it to go in front of a jury. Wayfair wants everything to be a legal issue. Nope, you don't need to take it in front of a jury. The law can handle this, Your Honor. And whether it's an MJOP or an MSJ, both of those are asking the judge to make legal decisions. It's just that in an MSJ, he gets to consider some of the facts when making the legal decisions. He gets to consider whether there is an issue of fact such that it needs to go in front of a jury, right? So when the judge is deciding these at the same time, what he's probably going to do is look first at whether it can be resolved with the MJOP alone. And if it does, just stop. And if it doesn't, then he can move on to motions for summary judgment and see if that standard, with everything he can include there, makes a difference. And then whether he says, nope, there's still nothing there, or yes, now that I've looked at it under this different standard, it changes things. But that doesn't mean he's not going to limit his determination in the MJOP to just the law. He could, let's say, in the MJOP be like, look, there's no fact in the world that's going to change the fact that there's no right to sue letter for it ends with us before the statute of limitations ends. So those claims are out. Those claims are out. And that's basically the case, right? He could pull some out and leave fact issues in others. He could say, Friedman's comments are covered by litigation privilege. We're not even going to consider facts. It is what it is. I'm going to protect privilege comments. That claim is out. But I think maybe there's a fact issue when it comes to the temporal proximity for causation. I don't think the law alone can solve that issue. So we're going to need to go look at the summary judgment, and then he can look at the summary judgment and decide if there's a genuine issue of material fact that needs to go to a jury. So what Wayfarer was trying to do was to say, we're going to file an MJOP. You can decide this stuff on the law. You don't even need to get to motions for summary judgment because you can decide this without looking at any of that. And what the judge has said was, you waited too late because now all of these facts have been gathered, and I'm not comfortable making a legal determination when I know that there are also arguments out there to be made by a different standard using different information. So I want to look at them both. What Lively wants to do either way is create issues of fact, right? Her job is to muddy the waters. Her job is to be like, this is not a question of law. This is a question a jury has to decide. You just want to kick, when you're opposing a motion, you just want to kick the can down the road. Now, what Judge Lyman was trying to ask Kevin Fritz the other day, where people were like, that was a weird interaction, because Kevin Fritz said, I'm not even sure we're going to file a motion for summary judgment. And Lyman was like, take that back. Of course you are. But I think what Fritz was trying to say is, our motion for summary judgment would look exactly like our motion for judgment on the pleadings because we're just going to make pure legal arguments, so why bother? So I don't even know if both motions are going to be on the table. But I hope that helps in understanding the difference in how they're treated. And ask me questions, and I will try to make you guys smart on this while these things are being written before they come.